How many of you have heard one of these before by Dean Chemerinsky? Most of you. That's why you're back here, I guess. He's the founding dean. He's a distinguished professor of law at UC Irvine. He helped put the law school together. He has this incredible background that I can't even get into of civic service. I guess that's the right word, and awards that I'm just not even going to mention. But he taught at USC for 21 years. He moved to Duke, taught at Duke Law School before coming back here to put the law school together for UC Irvine. He is one of the nation's leading scholars, commentators, teachers, and litigators in the Supreme Court and other high appellate courts. And just to do this formality, his law degree is from Harvard, sorry about that, and his bachelor's is from Northwestern. Please give a welcome the way you feel about Dean Erwin Chemerinsky. Hi, nice to see you.
Thank you.
Hello there. You have a mic.
Thank you. Thank you so much for the incredibly kind introduction and the wonderful warm welcome. It's really terrific to be with you again. The most long-lasting legacy of any president is who the president puts on the Supreme Court in the lower federal courts. Franklin Roosevelt left office in 1945, but the last Go ahead. My name's still Erwin Chemerinsky. Franklin Roosevelt left office in 1945, but the last of the justices that he put on the Supreme Court, William O. Douglas, didn't leave the bench until 1974. Richard Nixon left office in 1974, but the last of the justices he put on the court, William Rehnquist, didn't leave the bench until 2005. Ronald Reagan left office 25 years ago, and yet, when you look at it, there's still two justices on the Supreme Court, Antonin Scalia and Anthony Kennedy, placed there by Ronald Reagan. What I was asked to talk about this afternoon seems to me so obvious that one of the most important issues in the coming November election should be who's going to fill the next vacancies on the Supreme Court and the lower federal courts. Just to look at the current court and where the vacancies are likely to be, there are 3 justices on the current court who are in their 50s. Elena Kagan is only 52 years old. John Roberts, the Chief Justice, is just 57 years old. Sonia Sotomayor is 58 years old. There are 2 justices in their 60s. Samuel Alito is 62. Clarence Thomas has been on the Supreme Court now for over 20 years, but he's just 64 years old. There are 4 justices in their 70s. Stephen Breyer recently turned 74. Antonin Scalia and Anthony Kennedy are each 76 years old, and Ruth Bader Ginsburg is the oldest of the justices, having turned 79 in March of this year. Perhaps because she's frail in appearance, there's always speculation that she might step down. But I should tell you that I first met her in 1986 when she was a judge on the Federal Court of Appeals in Washington, D.C. She was quite frail in appearance even then, so I don't give too much weight to that factor. But besides that, I've long believed that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. But actuarial tables and simple odds tell us that the next president is likely to be able to fill 1 or more vacancies on the Supreme Court. And every time I mention the Supreme Court, I should also say that the Federal Court of Appeals and the district courts are also a long-lasting legacy of the president. Like for the Supreme Court, The judges on the Federal Court of Appeals and the District Court have life tenure. And when you think of judges now regularly being appointed when they're in their 40s, they can be on these courts for 40 years. The Supreme Court hears only a small fraction of the cases. Last year, the Supreme Court decided just 65 cases after briefing and oral argument, smallest number during my lifetime. There were over 9,000 petitions for review. That means in all of these other cases, other judges got the last word. So who's the president and who's filling the vacancy on the court is enormously important. Let me give you an easy example of this. It's a high-profile example, but an enormously important one. Will Roe versus Wade be overruled? Will women still have a constitutional right to choose? On the current court, there are 4 justices who undoubtedly are ready, willing, and eager to overrule Roe versus Wade. Chief Justice Roberts, Justice Scalia, Thomas, and Alito. There are 4 justices on the current court to protect abortion rights. Justices Ginsburg, Breyer, Sotomayor, and Kagan. That leaves Anthony Kennedy. He, on this issue, almost every issue, is the swing justice. Kennedy's view is that Roe versus Wade should not be overruled, but that almost any government regulation of abortion, up to a complete ban, should be upheld. Imagine that Justice Ginsburg leaves the court. If she is replaced by President Obama, should he be reelected, then nothing's going to change from the current situation. But imagine that she's replaced by Mitt Romney. I think everyone agrees that will create a 5th vote to overrule Roe. No longer will Kennedy be the swing justice. Now, on the other hand, imagine that it's Justice Scalia who leaves the court and President Obama replaces him. There will then be a 5th solid vote to protect abortion rights. The simple reality is whether women have a right to choose for decades to come is in all likelihood going to be determined by who's elected in November of this year. And I've done that as just one prominent example. The other way that I thought I could talk about this with you this afternoon is to imagine that when William Rehnquist and Sandra Day O'Connor resigned in 2005, that Al Gore or John Kerry had been president rather than George W. Bush. And what would have happened had they replaced Rehnquist and O'Connor rather than Bush replacing Rehnquist and O'Connor with Roberts and Alito? I think this is one way to see the effect of elections. It's also a way for me to talk with you about the current court and where it's at. Because I think if you look at every major area where the current court is at is entirely a function of who won the 2004 presidential election. So I thought what I would do, as always, is talk for about 40 minutes, then save the remaining time for questions. I apologize in advance that I have a 4 o'clock meeting on campus, so I need to be out of here just at 3:30. And I don't want to be rude, but I'll hurry out at that time only because I have a meeting that I have to be back for. But that should give us about an hour and a half together, half with me talking, and then half with any questions that you want. So where is the current court? And why do I say it's so much a product of the 2004 election? Well, one characteristic of the current court is that it's a very pro-business court. It is the most pro-business court we have had since the mid-1930s. It's easy to think of the court in liberal conservative terms, but sometimes I think that masks what's really going on. And what's really going on with this court, because Roberts and Alito joined the court in 2005, is how much it's pro-business. Let me give you a couple of examples of this from recent decisions. I'll use one from a year ago. There's a case called AT&T Mobility versus Concepcion. AT&T was advertising free cell phones. The Concepcions went to get their free cell phones. They, like all of us, had to sign an agreement to get their free cell phones. They, my guess is like most of us, didn't read the agreement they were signing. Had they read the agreement, they would have seen a clause that said, if they had any dispute with AT&T arising out of the cell phone, they could not sue AT&T in court. They would have to go to an arbitration process. The Concepciones were surprised when they got their first monthly statement, and they were each charged $30.22 in tax. Their view was, since AT&T promised a free phone, they should have to pay the cost of the sales tax. They shouldn't pass it on to the consumers. And the Concepciones learned that there was actually a lawsuit against AT&T in federal court for fraud, for offering free cell phones, but passing on to the consumers the sales tax. The Concepciones went to join this lawsuit. AT&T moved to dismiss their claim. AT&T said, you agreed you'd go to arbitration. You can't come to court and sue us. Now, there is a federal law. It's called the Federal Arbitration Act that says that courts should enforce contracts in interstate commerce that have arbitration clauses. But it has a big exception. It says, except if those clauses are revocable, not enforceable under state law. And the California Supreme Court had previously ruled, in a case called Discover Bank, that arbitration clauses in routine consumer contracts cannot be enforced in California. The California Supreme Court said, those clauses are unfair. Consumers don't get to bargain for those clauses. They're just imposed by business. And so the Federal Court of Appeals said that this clause isn't enforceable under state law, so the Concepciones can go to court. The Supreme Court 5-4 reversed the Court of Appeals and said the Concepciones couldn't sue. Justice Scalia wrote for the court, joined by Chief Justice Roberts, Justice Kennedy, Justice Thomas, and Justice Alito. Justice Scalia talked about the terrorizing effects of class action suits on businesses. That was his exact words. He spoke of the interim effect. He said class actions force businesses to settle non-meritorious claims. He said as a result, the Concepciones can't go to court. They must go to arbitration. The reason this matters so much is that arbitration clauses are increasingly common and ubiquitous. And they are so favored by business because business doesn't want to have to go before a jury. Juries tend to be pro-consumer, pro-patient, pro-employee. Not long ago, I went to see a new eye doctor for the first time, and the receptionist gave me this big stack of papers to fill out. And in the middle was a form that I was asked to sign that if I had any claims against the doctor, I couldn't sue the doctor in court. I'd have to go to arbitration. And I said to the receptionist, will the doctor still see me if I don't sign this form? She said, I don't know. Nobody's ever asked me that question before. That doctor did see me, but I've now heard from so many people of doctors who will no longer see patients unless they give up their right to go to court, no matter how serious the injury, and sign an arbitration agreement. Around the same time, I bought a new Dell computer. And as you know, when you use a computer for the first time, you have to click that you've read the terms and agree to them. And I confess, I always just click agree so I can use the machine. But in this instance, I read the terms, and sure enough, there was a clause that said that if any dispute with Dell arising out of the computer, I agree I would go to arbitration. I couldn't sue them. I wrote Dell a letter saying I did not agree to that clause. And in fact, by opening the envelope of my letter, they agreed that I could sue them if we had any dispute. Dell did not write back. The computer still works. Justice Breyer made a really important point in his dissent that explains why this case matters so much. He said, no one's going to go to court or even to arbitration for $30.22. Where we need class actions, a situation like this, where a large number of people each lose a small amount of money. And the Supreme Court protected corporations by closing the courthouse doors to all of these suits in individuals. Look at what the composition of the court was. 5-4, Roberts and Alito in the majority. I have to believe that if John Kerry or Al Gore had replaced Rehnquist and O'Connor, the case would have come out the other way. Let me give you another example with regard to this being a pro-corporate court. I think the most important one, it was already alluded to in the introduction, that's the decision from 2010 in Citizens United versus Federal Election Commission. In Citizens United versus Federal Election Commission, the Supreme Court held that corporations have the right to spend unlimited amounts of money from their corporate treasuries to get the candidates they want elected, so they oppose defeated. Just a little bit of background, though. This involved a provision of the McCain-Feingold Campaign Finance Reform Act, a law adopted in 2001, that limited the ability of corporations and unions to spend money on broadcast ads 30 days before primary or 60 days before a general election. In January 2003, in a case called McConnell versus Federal Election Commission, the Supreme Court 5-4 upheld the constitutionality of this provision. Justice O'Connor wrote the opinion for the court. She was joined by Justices Stevens and Souter and Ginsburg and Breyer. She talked about the risk that corporate wealth can distort the election process. Corporations have enormous amounts of wealth, and the worry was they could drown out other voices. She also expressed concern that when corporations are spending money out of their treasury, it's really shareholder money, and corporations could be spending the money of shareholders against their will. 7 years later, almost to the day, in Citizens United versus Federal Election Commission, the Supreme Court expressly overruled McConnell versus Federal Election Commission. So you've got to wonder, what changed in those 7 years? Did the court find some musty history of the First Amendment that led it to believe it made a mistake? Had McConnell proven unwise in practice? No, the only difference was that Samuel Alito replaced Sandra Day O'Connor. Alito joins with the dissenters from McConnell and with John Roberts, because the majority in Citizens United is Roberts, Scalia, Kennedy, Thomas, and Alito, to overrule McConnell. Imagine again if Gore or Kerry had replaced Rehnquist and O'Connor, Citizens United would have come out the other way. It is impossible to describe all of the effects, and I think pernicious effects, that Citizens United is having on our election process. There will be elections decided this November. Local elections, state elections, congressional races, just based on the ability of corporations to spend unlimited amounts of money. I worry, too, about the candidates who choose not to run at all because they know that corporate wealth will be laid against them. Now, I had not planned to talk about Knox versus SCIU. What's interesting about this case, which came down on June 21st, is that the Supreme Court gave no weight whatsoever to the right of unions as entities to spend money in election campaigns, and gave all of the weight to wanting to protect the dissenting members of unions, saying it wasn't even enough to let them opt out. Compare that to Citizens United, which gave all of the weight to protecting the corporation as entity and no weight to protecting the rights of dissenting shareholders. If you put Citizens United and Knox together, what you see is just in the last 2 years, the Supreme Court has tremendously strengthened corporations in the election process and tremendously weakened the role of unions in the election process. And that's going to matter as to who gets elected at all levels of government. So that's the first theme I was going to talk about with regard to the current court and showing you how elections matter, how it's such a pro-corporate court. A second theme that I think you should know about the current court is how much it's a pro-prosecution and pro-police court and how little protection it provides for us, the individuals. Let me give you a couple of very recent examples just in the past year. And my guess is that even if you follow the Supreme Court closely, you might have missed these cases. One is a case called Ryburn versus Huff, decided in January of 2012. Ryburn versus Huff arose not far from here in Burbank, California. A school learned from some of its students that another student might have been planning some violent activities in the school. The school did what it was supposed to. It called the local police. 2 police officers went to the boy's home. The boy and his mother came out of the house to talk to the police. The police explained why they were there. The boy was immediately dismissive. He said, "I can't believe that the other kids said this about me. I'm planning to do anything violent. I'm not thinking about doing anything violent. I haven't said I would do anything violent." They asked the mom, "Are there any guns in the home? Anything to make an explosive?" And she said no. The conversation ended, and the police officer said to the mom, "Can we come in and look around?" The mom said, "No. If you don't have a warrant, you're not coming in our house." The mom and the boy turned to go in the house, and the police pushed their way in to look around. The police didn't find anything. No charges were ever brought. But the mom sued the police for violating the Fourth Amendment. The law is clear that the police can't enter any of our homes unless they've got a warrant or at least probable cause and exigent emergency circumstances. None of these were present here. The police defended in court by saying that their actions were reasonable. The police said most parents in these circumstances would allow the police in, even welcome the police in. The police said to the court that the fact that this mom said we couldn't come in made us suspicious, and that justified our coming in. Well, the Federal Court of Appeals ruled against the police here. The Federal Court of Appeals said, if this is enough, then there's nothing left of the Fourth Amendment, because then the police could knock on anyone's door, and anyone who doesn't let the police in becomes suspicious, and that justifies the police being able to come in. The Supreme Court reversed and ruled in favor of the police. The Supreme Court said that the police action was reasonable under the circumstances. I haven't left out any facts here. How can this be reasonable under the circumstances? How can the police enter somebody's home without violating the Fourth Amendment if they don't have a warrant, if there's no probable cause, if there's no emergency? Let me give you another example, and again, it's one that I think shows the importance of presidential elections. Another decision from this year. It's a case called Florence versus Board of Chosen Freeholders. Man in New Jersey got arrested by mistake. Everyone agrees that it was a mistake. What happened was, several years earlier, he hadn't paid a fine, and so there was a bench warrant for him to come in and pay the fine. He did pay the fine several years ago, and the warrant should have simply been lifted. They made a mistake in their computer system so that even though he paid the fine, even though there's no longer a warrant, it still appeared as a warrant in the computer system. He got stopped for routine traffic violation. The police officer, as officer always did, checked for warrants and found this old warrant and arrested him, took him to jail. When he got to the jail, he was subjected to a strip search. He was moved to another jail, and he was strip searched again. After 6 days, finally, New Jersey realized they made a mistake. They released him. No charges were brought against him. And he sued and said, to subject me to a strip search without any suspicion that I've got drugs, weapons, contraband, violates my Fourth Amendment rights. Justice Breyer, in his dissenting opinion, describes in detail how these strip searches are done and how degrading and humiliating they are. They're done in front of other guards and inmates. The Supreme Court, in a 5-4 decision, ruled against him and said that jails can engage in routine strip searches without any need for suspicion that the person has drugs or weapons or contraband. Justice Kennedy wrote for the court, joined by Roberts, Scalia, Thomas, and Alito. Justice Kennedy said that the court had to defer to claims by jails and prisons of what needed to do for the sake of security. Now, Justice Breyer, in dissent, in addition to describing how the strip searches are done, explained all of the other screening procedures that were done for inmates to make sure they didn't have contraband and weapons. Also, Justice Breyer had a study that was done in New York at one jail where 33,000 inmates were subjected to a strip search, and only 4 were found to be carrying contraband or weapons. Justice Breyer made a common sense argument. He said, how likely was it that on that Saturday morning, Albert Florence got in his car and said, you know, today the police might arrest me and take me to jail, so I'm going to hide drugs or a weapon in a body cavity. It just defies common sense. Nonetheless, the Supreme Court rules that it doesn't violate the Fourth Amendment. I once more have no doubt, had Al Gore, John Kerry, replaced Rehnquist, Connor, rather than it being Roberts and Alito, the decision would come out the other way.